Good afternoon, everyone. It's a special pleasure and honor for me to greet in the joint event of the Annie and Paul Janowitz Chair of Human Rights and the Taubenschlag Institute of Criminal Law at Tel Aviv University Law School. I want to begin by saying how moved I am to have with us Ms. Livia Yanovich, who is visiting us from New York, and who's an old and new friend of the law school, of the university, and of myself. It's really touching to see how generations are tied with our institution, and it's not always, an easy sale, I would say, to have long-lasting relations. But I'm really happy that with the really unique Livia, we're able to maintain and even strengthen this friendship. And it's a special pleasure also to have Professor Carol Steiker. I won't present her, but it's also really moving because Carol was a professor of my best friend Yoav at Harvard Law School, and the topic of the talk today kind of made me reminisce a little bit about the time of arrival at Harvard Law School, which was I won't even say, but it was, I think, 25 years ago. Again, I won't take much time, but kind of thinking about the theme, which is the lessons learned, or what can we learn about the death penalty. I was kind of thinking that one of the things I remember that I was really proud of Israel when we arrived again at the US 25 years ago was we had a very low income inequality in Israel back then. I really remember stating the Gini index and saying how egalitarian Israel was. We had no anti-abortion movement, we had no gun rights movement, and we had no death penalty movement. And I remember saying, what an odd place is the United States. We have, I mean, it's on one hand so progressive. On one, you have gay rights, you have women liberation. I mean, you had all these wonderful things, civil rights, etc. Things that Israel didn't do very well back then. But I thought, and on the other hand, it has all these kind of weird things. Unfortunately, I would say, 25 years later, we're not doing better, and not to say we're doing a little less better on these fronts. Income inequality has become a lot worse in Israel. We have, I would say, budding or fledgling anti-abortion movement. Gun rights, we are also seeing that on rise. And unfortunately, also new discussions about the death penalty. So I'm really welcoming the discussion, and I think that there is no one else that can teach us more about that than Professor Carol Steiker. I guess these are going to be lessons of warning. So just to end with saying a huge thank you to Professor Yoav Sapir, who's heading the Taubenschlag Institute, and to our Professor Talia Fisher, who was actually, it's also kind of the inauguration of her reception of the Annie and Paul Janowitz Chair for Human Rights. So I hope we're going to have a beautiful and fascinating afternoon. And again, thanks to everyone.
שלום לכולם, שמי ליביה ינוביץ', אני שמחה להיות כאן ומודה לפרופסור טליה פישר ולפרופסור ישי בלנק שהזמינו אותי לשאת דברי פתיחה. ברשותכם אעבור עכשיו לאנגלית. So, hi everyone. Am I on this thing? Sort of? Okay. All right. Yes, I'll keep it close. So 43 years ago, which is an extraordinary number, my parents, Paul and Annie, established the first chair in human rights in Israel. They were passionate in their love of Israel, and this love manifested itself in their service in the Haganah, followed by service in Tzahal, the IDF, where my father helped found the Totchanim, which is the artillery corps, and my mother was one of the first 7 women officers, despite being a married woman. It was further expressed by being amongst the founders of the Tel Aviv Foundation and by raising me Le'ahavat Zion. I can attest to my father's fervent wish that by establishing this chair in the Faculty of Law and having Yoram Dinstein as its first incumbent, the State of Israel would finally have a written constitution, were it only so. Those of you in this distinguished audience who knew Paul and Annie know that neither was some radical leftist. On the contrary, they were known for their love of people and their open door to one and all. From my friend's Arab boyfriend, that's me, to my mother's gay couple caregivers, Ofer and his boyfriend, to every single taxi driver in the world whose opinion my father sought. It's bittersweet to stand here or sit here in their stead and yet be happy that they're not here to witness our country's turmoil. I do know that both Annie and Paul would have been delighted to meet Talia and be proud of her work both in and out of academia. I believe that they would have enjoyed Ishai as much as I do and be open to hearing Professor Steiker's words. So thank you very much for attending and enjoy.
So thank you so much, Livia. It's so nice to have you here with us. I'm so touched by your memories, and would really like to learn more about your parents, whose legacy I cherish a lot. And it's a tremendous honor and pleasure to have Professor Carol Steiker with us here today. Carol Steiker is the Henry J. Friendly Professor of Law at Harvard Law School, where she serves as the Dean's Special Advisor for Public Service. She's also a member of the American Academy of Arts and Sciences. New, and congratulations, Mazal Tov. She's a world-renowned expert in the broad field of criminal justice. Her work ranges from substantive criminal law to criminal procedure and institutional design, with a special focus on capital punishment. It merges theoretical analysis at the highest level with close and careful reading and understanding of the realities of the criminal justice system. The vastness of the scope of research conducted by Professor Steiker is matched by its depth and sophistication. Professor Steiker is the author of Courting Death, right here, co-authored with her brother, Professor Jordan Steiker of Texas Law School, as well as numerous other law review articles in the most prestigious of academic venues. Professor Steiker is a graduate of Harvard Law School, where she served as president of the Harvard Law Review, the second woman to hold that position in its then 99-year history. She clerked for Judge J. Skelly Wright of the D.C. Circuit Court of Appeals and for Justice Thurgood Marshall of the U.S. Supreme Court. Professor Steiker also worked as a staff attorney for the Public Defender Service for the District of Columbia, where she represented indigent defendants at all stages of the criminal process. In addition to her scholarly work, Professor Steiker has done pro bono work for indigent criminal defendants, including death penalty cases in the U.S. Supreme Court, and was appointed to the board of the Committee for Public Counsel Services, the statewide public defender for the Commonwealth of Massachusetts. Professor Steiker has served as a consultant and expert witness on issues of criminal justice and capital punishment for nonprofit organizations and has testified before Congress and state legislators. So please join me in welcoming Professor Steiker as our distinguished guest speaker today.
Okay, so hello everybody. Thank you, Professor Steiker, for being here. I am also thrilled and honored. So since it's going to be a discussion, a conversation about what Israel might learn from the American experience, and Carol is going to speak a lot about the American experience, just by way of introduction, let me say a few words about death penalty in Israel and the bill that is currently on the table. So as some of you probably know, Israel inherited its criminal code from the British Mandate, and the British code included death penalty for murder. Right after the independence, there were attempts to abolish it, partly because it was seen as an oppressive tool of the colonizer. Actually, it was used, and some of the members of the underground, Jewish underground fighting the British were executed. In 1954, the law that abolished death penalty for murder was passed. Death penalty remained for treason and for Nazi crimes. That's an original law enacted by the State of Israel. It was only used twice in the history of Israel. So 2 people were executed. Both are very unique cases. One of them is the famous Eichmann trial. I think the execution was 1962. And before that, right during the Independence War in 1948, a soldier called Meir Tubiansky was sentenced to death for treason in a martial court. A very quick trial was happening there, and then it was found out that it was a mistake, it was a false conviction. And Ben-Gurion issued an official apology, but these are the 2 cases of executions in the state of Israel. The bill that is being presented now is aiming at reinstating the death penalty for murder. It has, other than the fact that death penalty in general is very unique and unusual for us, it also has 3 very unique characteristics. The proposal, one of them is that it is going to be just for terrorist attacks. So there should be a motive of terror. Secondly, there's in order to make sure that it only applies to non-Jewish terrorists, so there should be a motive, I'm quoting, in circumstances where the act was done with the aim of harming the state of Israel and the revival of the Jewish people in its country. So that's a motive that's in the bill. So if it's a murder that was done for another motive, the death penalty will not apply. And the third is that according to the bill, death penalty under these circumstances are going to be mandatory, so no judicial discretion at all. My first question, so basically the death penalty was, although it's still in the books, it was abolished. I mean, Israel is considered to be a state in which the death penalty was abolished, and now there's an attempt to reinstate it. So my first question to Professor Steiker would be, are there any states or countries that abolished the death penalty and are trying or has successfully reinstated it? Since we know that death penalty is in decline both in the US and globally, what can you describe the state of the death penalty just in general and in introductionary way in the US in terms of states abolishing it, numbers of executions? What is the trend in the US and globally?
Well, I'm happy to answer those questions, but before I do, was that me? Oh. I just want to thank Dean Yishai Blanc and my former student and friend, Yoav Sapir, and my friend and colleague, Talia Fisher. It is such a pleasure to be here with like three of my favorite people in the entire state of Israel. So I'm so delighted to be here and to have this opportunity to talk to you, although I'm not so delighted that a talk about what Israel might learn about the death penalty from the U.S. is like a good topic to talk about today, but it is. So, Yoav, you had two questions. So I'll start with the second, which is just sort of a general state of the death penalty in the U.S. and in the world. And the state of the death penalty in the U.S. and the world are mostly on the same track, which is, I would say, in great decline. So, you know, in the 1960s, only 12 countries in the world had abolished the death penalty completely. Today, more than half of the roughly 200 countries in the world have abolished de jure, and more than 2/3 of the countries in the world have abolished either in law or in fact. So there's been an accelerating movement away from the death penalty around the globe. Even so, the one country in the world that executes more than probably, we don't know for sure, the rest of the world combined is China. They don't, issue formal numbers, but I have many colleagues who work in that area of the world, and they have people on the ground who say that even in China, the use of the death penalty has declined probably by 50% in the last 10 or 15 years. So even there. And so that is true in the United States. So just to give a sense of the sweep of the death penalty in the United States, so right after World War II, the death penalty was in decline, in major decline in Europe and in the US. So, Germany and Italy in their post-World War II constitutions abolished the death penalty, and other countries began to abolish, and the death penalty was really decreasing in numbers in Europe and in the US. So much so that by the 1960s in the US, we had declined from like 100 to 150 executions in the 1930s per year to maybe a dozen or fewer per year in the 1960s. At the same time, who was carrying out those few executions in the United States in the 1960s? It was almost exclusively the southern states and almost exclusively black men convicted of crimes against white victims, usually rape against white women. So this was the backdrop against which our Supreme Court in 1972 ruled for the first and only time that the American death penalty violated the Constitution. It was cruel and unusual punishment under the Eighth Amendment. The court held in a landmark case, Furman versus Georgia, in 1972. At that time, 40 states and the federal government had the death penalty, and in that one day, the death penalty was wiped out in the U.S. But it was a very weak holding because it was, first of all, 5-4 on our Supreme Court, and among the 5, there were 5 different opinions written by each of the justices, and not a single one of them joined each other's opinions. So it was very hard to say what was the ruling because they had all different kinds of reasons. But it was taken to be that the 2 centrist justices among the 5, that was considered to be the heart of the matter, and their objection to the death penalty in 1972 was that it was extremely widely authorized, so like the opposite of the new Israeli law. You could get the death penalty in many states for not just murder, but rape, robbery, kidnapping, burglary, and juries. Capital sentencing in the U.S. is done by juries. Even though judges sentence in most criminal cases, it's traditional in the United States that juries are the sentencer in capital cases, and juries were given no guidance as to who among all those people should get the death penalty. They were just told in a capital case, it is according to your conscience, it is in your sole discretion, You decide. And so the Supreme Court said that system of broad, extremely broad authorization and tiny use with no guidance at all to the juries was cruel and unusual. It was capricious. It was arbitrary. It was, in the words of one of the centrist justices, like a being struck by lightning to get the death penalty. So the Supreme Court struck it down, but because they did not say that the death penalty was always unconstitutional, just unconstitutional because of the system, many states immediately moved to bring it back with new statutes that would give guidance. In fact, on the very day that the announcement was made in the New York Times that the Supreme Court had abolished the death penalty, and it was a headline as big as when we landed a man on the moon. That's how big the news was. Supreme Court abolishes the death penalty. Underneath it says, Nixon vows to bring back the death penalty for airline hijacking. So that was the terrorism of our day, right? 1972, it's 4 years before Entebbe. Like, airline hijacking was the terrorism of the time. So it was not, there's some parallel there. Within a few years, 35 states and Congress, the federal Congress, had brought the death penalty back. So everyone knew the Supreme Court was going to have to rule on this new generation of new and improved death penalty statutes. And in 1976, so just 4 years after the Supreme Court had abolished the death penalty, the Supreme Court upheld some of the new guided discretion statutes. The American death penalty was back in business and really went roaring back to life, so that by the end of the 1990s, we hit a peak where the peak of new death sentences was 315 new death sentences a year, and the peak of executions was 98 executions in a year, and that's the late 1990s. But then a strange thing happened, which is starting at around 2000, the turn of the millennium, the death penalty, so the death penalty went up, 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 and now in the last 20 years in the US, the death penalty has gone down, 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 down. So just if you charted it, it looks like a roller coaster. So that in the last few years, it's a little hard to say because of COVID. There were like almost no death sentences and executions during COVID because courts were not really sitting. It was hard to get juries in. But if you look from the years right before COVID, death sentencing, maybe 30 death sentences a year, down from 315. That's like a 90% decrease. Executions, maybe 20-ish executions a year, down from 98. That's like an 80% decline. Huge decline in death sentencing. And Texas is the state in the United States. It's like the China of the United States. If Texas were a country, it would be the third leading executor in the world. Even in Texas, executions and sentences are way, way down. And we can talk in the Q&A if you want to know a little bit more about why that might be. But it's been a fact for a long time, and there's no good reason to think that that fact is going to change. So the death penalty is in strong decline in the U.S. and around the world. So that's like your first question, a little snapshot of where we are. The other question is, anyone trying to bring it back? No countries have successfully brought it back. I mean, you may remember that New York State had abolished the death penalty, and Governor George Pataki, when he was elected in 1995, he did bring the death penalty back, got it passed, sentenced a whole bunch of people to death, no executions. 10 years later, the state Supreme Court struck it down on a pretty much technical ground that could have been fixed, but then the Democrats in the New York State legislature fully in control. They've never brought it back. So there's a relatively recent example of a return and then again in abolition. But around the world, there are few countries that have talked about trying to bring it back. One very timely is President Erdogan of Turkey. I mean, I don't know what's the latest. It's like he's like it's this close, but he has. Yeah, they're in another round. Yeah, so he's like right on the edge of being continuing to be president. He has made it a big feature of his policies to want to bring the death penalty back to Turkey. President Duterte of the Philippines similarly has said that he really wants to bring it back to the Philippines. And within Europe, this is not really serious, but President Orban of Hungary has said that he would like to bring it back, but he's not going to. Yeah, it's really great company to be in, right? And I have to say, I'll tell you one more person, but I don't think it will happen. It definitely will not happen in Hungary, because in Europe, if you're to be a member of the European Economic Union, European countries have to sign Protocol 6 of the European Convention on Human Rights, which forbids the death penalty. So if any European state that's a member of the EU, as Hungary is, were to bring the death penalty back, they would be kicked out of the EU, the Economic Union. And so that is a good backstop. That really prevents European backsliding on abolition. I can't promise the same thing for Turkey, which is not a member of the Economic Union, certainly not the Philippines. The one other person who's been a big enthusiast is former President Donald Trump of the United States. In the 50 years prior to the Trump presidency, there had been only 3 federal executions, the most recent of which had been 17 years before Trump became president. In the last 6 months of his presidency, he authorized and managed to get executed 13 federal prisoners. So more than 4 times as many federal prisoners who'd been executed than in the past 50 years combined. And so he was a big enthusiast. You can see that strong men, populist leaders really see in the death penalty something attractive. It's not a great story.
So thank you, Carol. So first of all, it's very depressing to see the company of states that are trying to reintroduce the death penalty. You're describing the movement of de facto or de jure abolition throughout the world, and in your writing you describe the situation in the United States. You just describe it. You term it as abolition in waiting. We seem to be facing the mirror image situation of a death penalty in waiting, whether it's this round or the next, it's looming above. And I wanted to ask you about that, about this climate of a death penalty either ultimately being enacted or just sort of in the shadow of this prospect of a death penalty in Israel. How, in your opinion, would that impact the criminal justice system generally? So would it make us perhaps less sensitive to a general enhancement of punishment? Would it how would it affect the system outside of the death penalty apparatus, even if this current proposal does not ultimately materialize into legislation?
Yeah, I think that's an excellent question. And I think you can see from our own experience, the death penalty, it absorbs so much of the attention and the political action that it kind of leaves untouched other really extreme practices that we have. So in addition to being an outlier among Western liberal democracies, developed democracies, and having the death penalty, the US is also an outlier in having and using the punishment of life without possibility of parole. And we use that a lot. About 1 in 9 prisoners in the United States are serving a life sentence, either with or without parole. And more these are becoming non-parolable offenses. So LWOP, as we call it, LWOP, life without parole. LWOP. Now you can sound like an American criminal law person. LWOP gets very little attention in the U.S. because we say, well, it's not the death penalty. You know, for these, the kind of crimes, many of the serious crimes that you could get LWOP for, well, at least it's not death. And so death ends up, some people say it creates sort of a vacuum at the top, and it just pulls up the range of punishment and dampens critical scrutiny of other serious punishments like LWOP. Also, you know, another big problem in the United States is prison conditions, and our prisons are overcrowded, and they're dangerous, and they're violent, and they're sexually violent, and there are a lot of deaths of prisoners in prisons for all kinds of reasons, and yet prison conditions is like, well, they're not dead. I mean, some of them are dead, but they're not being executed by the state. And there's this sort of sense of, well, how can you complain? It's not, you know, it's not the worst that the state can do to you. So that anything that's not the worst that the state can do to you, I think, tends to fly below the radar. And in fact, you know, the conservative students at Harvard Law School, every year they invite me to debate the person of their choice about the death penalty. And that person always says, you know, we know your types. The minute we get rid of the death penalty, you're going to start arguing about LWOP. And it's like, yeah, it's probably true. I don't actually say that, but that is true. And I say one of the good things about getting rid of the death penalty is we can have an honest conversation about some of these other things, which we can't really when the death penalty is looming. And I wonder if you think that might be the case here. I don't know.
Yeah, just a follow-up. So the scale is very different. I remember when the Supreme Court, I think it was Justice Kagan, who it was Miller maybe, when she ruled, the Supreme Court ruled that life without parole, mandatory life without parole for juveniles is unconstitutional. It was only in, I mean, not 10 years ago. So in Israel, we don't have life without parole. We definitely don't have it for juveniles, and we definitely don't have it as a mandatory. So, so it seems to me completely right that once you have the death penalty, or once you abolish the death penalty, maybe you'll start thinking about the other measures. And it's a way also alarming to think if we did have the death penalty, what would it do? What would be the consequences for other penal measures in Israel? You mentioned the effect back in before Furman, the fact that race was a major issue in the application of the death penalty. But you've written about the fact that it still is a major issue. Not only back then, the Supreme Court in the famous case of McClaskey was presented with clear evidence of disparate impact, racial disparate impact, rejected the argument that this counts as unconstitutional. And since then, so how is it since then? I know that the Supreme Court, you've written about or criticizing the Supreme Court about ignoring that fact or not paying enough attention to the racial issues within its jurisprudence of the death penalty.
Yeah, that's a very important question and a complicated one. Back when the Supreme Court first got involved, the overwhelming there was tremendous discrimination against black defendants because the death penalty was used very much in southern states for the crime of rape, but only for black men who raped white women. So white men who raped white women never got the death penalty. Black men who raped black women never got the death penalty. Only black men who raped white women. That disappeared because in 1977, the court ruled that we can't have the death penalty for rape, period. They didn't mention race, although that was clearly what was going on. But they wanted to, it was just a very embarrassing thing for the United States. So now you can only have the death penalty in the United States for murder and for crimes against the state, terrorism, treason, possibly drug crimes. Like technically we have a federal death penalty for drug kingpins that has never been applied, but it's a question about whether that would be constitutional. So today there have been many, many, many studies, including the study that was done in McCleskey, statistical studies controlling for many, many variables, trying to see the impact of race on capital sentencing. And what's interesting is the hugest impact is not so much the race of the defendant, but the race of the victim. So that the death penalty is used almost exclusively in cases of white victims, almost never in cases of black victims, and among white victims, overwhelmingly used for black defendants who kill white victims. But because of racism in the United States and our long history of racism, there is a much higher homicide rate among black defendants than white defendants. And the vast majority of homicides are intraracial, not interracial. So the vast majority of homicides are white people killing white people and black people killing black people. But because there's more homicide in the black community, when you run the statistics, you don't see a big race of the defendant effects, because all of those black people who kill black people never get the death penalty. So you see a very strong race of the victim effect, and then within that category, interracial killings of white victims are, and this, many, many, many statisticians have done these studies, and they over and over and over and over again find the same information. But the problem is the Supreme Court has said you cannot use statistics to show a violation of equal protection of the laws. So patterns will not give you a constitutional claim, only if you can provide proof that there was discrimination in your individual case, which means you need the prosecutor or a juror or the judge to say, yes, the reason the death penalty is being, yes, you need to prove intentional discrimination in your individual case. And you won't be surprised to know that the number of cases in which that has been proven ever is 0, because you can't prove that. Now, what's interesting is there is some movement, not in the Supreme Court and not in Congress. Nothing good ever happens in those places. But about 5 years ago, the Supreme Court of the state of Washington struck down its own state's death penalty on the basis of a statistical study that showed racial discrimination. Once again, it was much stronger race of the victim than race of the defendant effect. But the Supreme Court of Washington said, unlike the U.S. Supreme Court in McCleskey, we think statistics are fine in terms of proving discrimination. And based on this, we find that our death penalty is unconstitutional. So that moved Washington state into the abolitionist camp. By the way, right now, 23 of the American states have now abolished the death penalty, and 27 still have it, and the federal government still has it. So that's an interesting. They're the only Supreme Court to specifically rule only on the ground of race. But for example, the Connecticut Supreme Court, which abolished the death penalty in Connecticut about 10 years ago, race was one of a number of reasons why they found the death penalty violating their constitution. But there's also been some relatively recent legislation. So in California passed a Racial Justice Act, which allows you to challenge the death penalty based on either statistical proof of discrimination. So similarly, you can use statistical proof of discrimination to challenge the death penalty in your individual case, or the striking of jurors on the basis of race. So this is a big thing in the US. Like, prosecutors know that black prospective jurors are much more likely to be against the death penalty because of the tremendously racist history of the death penalty in the United States. And so prosecutors try to strike. They get a number of what are called peremptory strikes. They can strike jurors for any reason they want except for race. And they claim that I'm striking them because he smiled too much, or he didn't smile enough, or he stared at me, or he wasn't looking at me, or and there's a lot of racial use of these strikes, and this California Racial Justice Act allows you to challenge a death penalty based on that. So there is some movement, but it's not widespread. We've got one state Supreme Court and one state statute, and maybe there will be more.
Thank you, Carol. So just a small follow-up. It's very, very fascinating. So you're talking about especially the victim, the effect of the race of the victim. I suspect we'll be seeing that as well here. But, you know, in our proposed bill, the race or the ethnicity of the defendant is in an explicit, shameless manner just you know, laid out there. It's targeted towards Palestinian terrorists and not Jewish terrorists. And just, I was wondering, in light of this, you know, racial legacy that you just mentioned, to hear more about your thoughts about not just the ethnic divide, but also the use of the death penalty, not just in the United States, but perhaps in the world, as a political tool, as a political
Yeah. I mean, absolutely, the death penalty has been used throughout history to, you know, suppress dissent and punish political enemies. I wouldn't say that that is. I mean, there are many, many, many things wrong with the American death penalty, but that's probably not one of them. But I will say, so there's two things about the Israeli statute that that would not be permissible in the U.S. So these are, you know, it's like, one is the explicit racial category. So we do have a category of what are called hate crimes, where it's a worse crime to commit it on the basis of some kind of bias. But it would be unconstitutional to say only one kind of bias and not another kind of bias. So like bias against, you know, black people but not against white people, or against Hispanic people but not against black people. That's pretty clearly would violate an equal protection, the equal protection clause of our Constitution. So that part of your law would not last 10 minutes. And interestingly, the other part of your law that would not last 10 minutes is the mandatory nature of the statute. Because back in 1972, when the Supreme Court said all of this unguided discretion was the problem, 12 states passed mandatory statutes in response. So the idea was, like, maybe we can fix the problem of too much discretion with a mandatory statute, take the discretion away. And our Supreme Court said, one, actually mandatory statutes don't solve the problem of too much discretion, because the jury, or in your case perhaps the judge, could always decline to convict of that particular crime and convict of some other crime instead, lower level of homicide instead, and avoid the death penalty. So there would still be discretion, it would just be invisible and it would fly below the radar. But more importantly, our Supreme Court said that we needed to have what it called individualized sentencing, so that you need to consider what our court calls mitigating evidence, or the reasons why someone may have committed the crime, or their youth, for example, or their disadvantage, or their mental state, or their perhaps mental illness, all things that might be important to decide not just whether the person committed a particular kind of offense, but whether they were someone who in fact deserved the death penalty. And in very poetic language, I love the language from this part of the Supreme Court's opinion, they said, a mandatory statute that fails to take into account the diverse frailties of humankind. I love that. The diverse frailties of humankind. But instead subjects a class of defendants to the blind infliction of the punishment of death is cruel and unusual punishment. So the discriminatory aspect of your statute and the mandatory aspect of your statute would not last in the U.S., but I think is, as you say, more in line with the illiberal use of the death penalty, not as a sort of neutral, cool, bureaucratic tool of crime control, but instead as a political weapon. In the U.S., even with its great racial bias, I would not say that we have much of a history. Not never, like I think of Sacco and Vanzetti. I don't know if you know who those folks are, but Italian anarchists who were executed in Massachusetts back in the 20s, I think. Yeah, but we don't have a huge history of that.
Thank you. I would like to touch upon a little bit about the different objections to the death penalty. So perhaps we'll talk about utilitarian versus deontological objections. But before that, a question about innocence. So one of the most horrific characteristic of the death penalty is that it is irreversible. And I just, in my introduction, gave the example of Meir Tobiansky, who was executed, and he was clearly innocent. So is this still a major innocence? Because generally innocence is a major concern in the American criminal justice system since the 90s as the development of DNA. Is it still a major concern regarding the death penalty, and what role does it play in the movement for abolition?
Yes, excellent questions. It's still an incredible issue. We now have a national registry of exonerations in capital cases. So I just want you to think this registry only counts as an exoneration someone who has been fully pardoned by the governor or the president, someone whose case was reversed on appeal and were retried and acquitted of the crime, or someone who the prosecutors dismissed all criminal charges against. So it's a pretty strict version of exoneration. How many, just think of a number in your head. Like how many do you think are on this national registry? It is only in capital cases, only death penalty cases. The number is 185 people have been exonerated from capital convictions while they're on death row. We have not yet, all of them were exonerated before they were executed, although one of them was like within an hour of the scheduled execution. So it's definitely an issue. Scholars have studied the phenomenon. So there's a scholar, Brandon Garrett, who wrote a book called Convicting the Innocent, where he did a deep study of the first 200 or 250 cases of DNA exonerations, where DNA exonerated the person to see what went wrong in their trials. And he came up with, basically 5 categories of things that go wrong. So false identifications. People think they're good at identifying people, but they're not. And in the US, cross-racial identifications are particularly vulnerable to error. Junk science in the technical, maybe next to Israel, but I'd say US is up there. We got MIT, we got Caltech. It's amazing how bad forensic science is, junk science. Another reason, false confessions. So our interrogators are very good at getting people to confess falsely, especially from young people or people with mental illness. Bad lawyering. We have very, public defenders, no offense, but they're very badly paid in the US, and they're often very, very ineffectual. And police misconduct. So police suppressing evidence of innocence or that another person might have done the crime. So those are all the kinds of things that can go wrong. And one scholar has calculated what the rate of error is in capital cases, and it's roughly, he says, and he's Sam Gross, University of Michigan, 4%. And you just think about that. Like, would you fly in an airplane if 4 out of every 100 airplanes like fell into the sea? So it's a pretty high rate, and it's higher. What's interesting, it's higher than the estimated rate of error in non-capital cases. Even though capital cases get more resources, there is so much pressure on law enforcement, and this may be very relevant. So when there's an atrocious crime, there's so much pressure to find the person quickly and say, we found the person, here's the person who did it. And then there's so much pressure on the court, in our country, in the jury, but on the judge, to not have that person acquitted, in their courtroom, that the pressures in capital cases are intense. Plus, the victim, or victims are dead. So the best witnesses to the crime are not there. And there's a lot of incentive on the people who really committed the crime to set up somebody else and falsely, lead to them. So it turns out capital cases have a higher projected rate of error than non-capital cases. So it's a big, big problem. But the tiny little ray of light is that innocence is the issue that changes the most people's mind about the death penalty. So that it is the biggest lever of moving public opinion. And people will tell you that is the, when you ask people, are you for or against the death penalty, and they're against the death penalty, that's the number one reason that people give for being against the death penalty.
Thank you, Carol. So that's so interesting. First of all, just about the DNA exoneration project. So it's really, on the one hand, we have these suspect categories of evidence like false confessions or eyewitness testimony, and one, ought to think whether this is just the tip of the iceberg, because in most cases we can't run a DNA, either because it's not relevant to the type of offense or because time has passed and we haven't preserved all, so it's very particular cases in which we can actually run these exonerations. But your point really makes one wonder about the general category of convictions and what is the rate of false convictions. On the other hand, as you point out, and I totally agree, that there's a selection effect with these DNA cases, and specifically with the capital punishment cases within them, where, again, interrogators might exert more pressure to extract the confession than other cases, etc. So it's hard to know, there's probably an overrepresentation of these types of conducts in this category, but I think we should be very mindful of just the general phenomena of false convictions in society and these specific categories. I want to move on from the innocence point to what I was mentioning about the deontological and more consequentialist types of justification. So I think, as to my understanding, as far as terrorism goes, I think there isn't sufficient or adequate empirical data showing or evidence showing that the death penalty would contribute to eradicating terrorism more than other types of more humane punishment. But for the sake of the argument, suppose the case were that we could show that there's strong empirical evidence suggesting that if we use this mechanism, we will have lower rates of terrorism, or we would deter terrorism. And the question is, if this were the case, what would be your stance on this? And I want to mention to the crowd here, there's a very, very well-known debate in this literature on capital sentencing between you and Professors Cass Sunstein and Adrian Vermeule. They employ consequentialist ethics, saying that if we were able to show that there is a significant deterrent effect to the death penalty, then we would be morally required to implement it. Whereas I would like you to, if you could elaborate on your position on this matter, and why you reject this consequentialist.
Yes, Cass Sunstein and Adrian Vermeule are my colleagues. They weren't my colleagues when they wrote this article, and I wrote an article. They said, "Is capital punishment morally required?" That was with a question mark. That was the title of their article. I wrote a response that said, "No, capital punishment is not morally required," and they were published in the same issue of the Stanford Law Review in 2005. And just when that issue came out, they joined my faculty. So it was like, welcome, welcome to my faculty. So we're all colleagues now. But their argument at the time, there was a little cottage industry of econometricians, statistical analyses that seemed to show that the death penalty saved more lives than, a lesser punishment for murder. And one of the most provocative of the studies claimed that each execution saved 18 innocent lives, like prevented 18 murders. And Sunstein and Vermeule said, we're not economists, so we're not saying whether this is correct or not, but if it were correct, and it certainly looks very impressive, they said, if it were correct, we should be obligated to have the death penalty. And they most provocatively said, not, if you're a consequentialist, you count lives against lives. So it wasn't so strange for them to say a consequentialist should agree that 18 lives over one life, that consequentialists would support the death penalty. But they said, in addition, deontologists, so rights-based theorists who had a moral opposition to the death penalty, should also support the death penalty, because even when people have a, categorical moral position as a deontologist, many deontologists have what they call a consequentialist override, a threshold override, so that if enough people were saved, that they would, so that the classic example is if there's a bomb under New York City, can you torture the terrorist who knows where the ticking time bomb is? And that, even people who think torture is categorically wrong say, well, you should torture the terrorist who knows where the ticking time bomb is to save 5 million people. And so they said, accepting this idea of a threshold override, deontologists should support the death penalty if it really does save 18 lives. So I originally was going to co-author my response with two economists, John Donahue and Justin Wolfers of Stanford and Penn, and we ended up splitting because they were like, it was all equations, and I just, didn't understand what they were saying. And I was like doing the moral philosophy, so we had two separate responses, and Donahue and Wolfers said these studies are crap, and they don't, and in fact, later on, the National Academy of Sciences, capital punishment deters better than murder. But there's also no evidence that it doesn't deter better than murder. So the absence of evidence is not evidence of absence, as economists say, but they did say that these particular studies did not pass muster. But my argument, and I was talking to Yoav about this a few days ago, was that speaking from the deontological perspective, if one thinks that the death penalty is morally wrong, and I spent a good part of the article explaining why I fell into that camp of thinking that the death penalty was morally, categorically wrong, even if I had a threshold, and even if my threshold were 18, which I think it's a little higher than that. But even if I had a threshold, and even if my threshold were 18, I would still not be moved by their argument, because the arguments about threshold overrides make more sense in the context of the ticking time bomb, when there's no time to do anything else. Either the bomb goes off or it doesn't go off. There's no time to do anything else. It's an emergency situation. Criminal law is, by definition, never an emergency situation. The whole idea of deterrence is that we do something to this person so that that person later on will make a different decision. But if you think it's categorically wrong to do something to this person, there's always something else you could do to change the incentives of this person. So you could put more police on the street to prevent, or you could invest in, drug treatment or anger management or poverty amelioration or whatever. There's so much that one can do to prevent future offending other than kill this person, that if you categorically think it's wrong, and you have a whole menu of other things you could do to change the incentives or change the outcome in the future, a deontologist would never say that my threshold, all right, you've met my threshold, agreed. So that was my debate with Sunstein and Vermeulen. I wonder what the rest of you think. I teach a course in Harvard College, so not at the law school, but to the very first year, teach a seminar to freshmen in the college. And I present that, I have them read this debate, and I make them say whether they would, kill one person to save millions, and that they're very tormented by this.
That's fascinating. Unfortunately, we're nearing the end of this conversation, but before we open it to the floor, this is maybe it's a question that kind of summarizes 3 decades of your scholarship. So I don't know how you could do that, but you've been studying and writing about the Supreme Court regulation of the death penalty. And after all these years, how do you look back on its regulation? And particularly if you can say something about the problem of legitimation that you and your brother, Jordan Steiker, wrote about from the point of view also of the lawyers or the abolitionists. You raised the thorny question, should abolitionists support reform in the death penalty? So reform that can, on its face, look humane and fair, such as DNA testing that ensures that we do not execute innocent people, or limitations such as mental retardation, abolition of death penalty for mentally retarded people. Can they play a role in legitimizing the death penalty altogether? So if you could say a few things about that.
I'll try to be brief. Boy, that is really that's my career's work. But my brother and I wrote that when the Supreme Court brought the death penalty back in 1976, that was the first time that it officially said there's nothing per se wrong with the death penalty. So they said in 1976. And these new statutes are, good enough at guiding discretion that it's not a problem. But we'll keep an eye out in the future and keep supervising the administration of the death penalty in the United States, so that every year now the Supreme Court issues rulings about death penalty cases. And if you're a lawyer in the US and you have a question about the death penalty, who are you going to ask? Everyone knows you ask our Supreme Court. Can you have the death penalty for crimes other than murder? Ask the Supreme Court. Can juveniles get the death penalty? No. As of 2005, they can't. Ask the Supreme Court says, can people with intellectual disability get the death penalty? No, says the Supreme Court. So we know that's who you go to. And because the Supreme Court has played this role of oversight and regulation, we argue that it actually played a role in that big upward trajectory of the death penalty after 1976, because it sort of reassured critics of the death penalty that the death penalty was being regulated, maybe even over-regulated. The Supreme Court was all over it, issuing rulings right and left, so that it seemed as if the death penalty was fair, more than fair, in the US. And I think it dampened the power and the energy of the abolitionist movement. But, so we wrote that article in 1996, near the peak of the death penalty. And then, to our surprise, the death penalty began to fall. And so we wrote another article 20 years after that, where we said, but interestingly, the United States Supreme Court's regulation of the death penalty has also played a role in undermining the American death penalty. Partly all of its rulings and procedural, you must do this, you must do that, have raised the cost of death penalty trials. So a lot of states have studied, because their state budgets are tight, and the cost of the death penalty has been enormous. So in California, this is one of the reasons California is really, I think, on the verge of abolition, is that they've only executed 13 people since 1976, but they've sentenced probably 900 people to death, but they're just very slow and at getting them executed. So that if you divide the amount of money that California has paid for having the death penalty by the 13 executions that it's had in the last 50 years, granted, it's a little sophistic to do that, but you get a cost of about $400,000, like almost $500 million per execution. When you think of that, 400,000, so 0.4 billion, almost $500 million for each execution. And when you think of like, what could you, billion, $400 million per execution. Yeah, I got it's whole numbers of zeros. It's hard. So 400 million per execution, 0.4 billion per execution. Like, what could you do with almost $500 million to make California safer, other than execute another person? So this has been a big argument. So the Supreme Court's regulation is part of what has, made death sentences harder to carry out. And the court's insistence that as a matter of constitutional law that you must consider the diverse frailties of humankind, I have to say this is where we public defenders have really saved the day. So there's been tremendous growth in so-called mitigation defense and bringing the defendant's life to bear so that Zaccaria Moussaoui, I don't know if you remember, he's the so-called 20th hijacker. He was arrested in August of 2001, and so he wasn't able to participate in the actual 9/11 bombings. But he was the so-called 20th hijacker. The federal government prosecuted him and sought the death penalty, and the jury gave him a life sentence. And it was, that's the kind of case where you might have thought, and maybe that's why Israel wants it to be mandatory, because your death penalty lawyers could learn from ours about mitigation and how to present a case to a jury that humanizes even the 20th hijacker in the 9/11 bombings. So that's another thing that the Supreme Court at first legitimated, but then ultimately, we argue, undermined the death penalty. You want to hear more about it? Read my book. Thank you so much.
Okay, thank you. It's interesting how money plays after all these moral arguments. Then actually, money can play a very important role I think not only the death penalty, which is extremely expensive, but also incarceration. So we see a movement that says, okay, we had tough on crime, we had smart on crime, now there's cheap on crime because incarceration costs too much. And also we mentioned the racial disparities. So of course poverty also plays a role. And there's this wonderful article by Steve Bright who says death penalty not for the worst offender, but for the worst lawyering, or something like that, where he actually proves that how the quality of lawyering is important. So it was great. Thank you so much. And I'd like to open the floor to questions or comments.
Hi, I'm Shai. I'm a public defender. I deal with legislative proceedings in the Knesset, and I hope this discussion will remain theoretical in Israel. My question is, I get the feeling when we talk in a closed room about death penalty, we kind of convince ourselves. And my dilemma, especially if this bill will carry on, is how do I convince, what arguments are the most convincing towards people who support death penalty, specifically in the special circumstances that we discussed before in terrorism attacks. The moral argument doesn't seem to work. It's a matter of ideology. Then there's always a moral argument that supports the death penalty, although I completely disagree with it. Also, when we try to talk about the fact that this penalty is irreversible, then I think we get the counter argument that many of the terrorist attacks are it's very obvious that this is the person who committed the crime is, we know it. Sometimes it's even filmed, and so we don't have this chance of a mistake. And also the let's say the international argument, the global trend, doesn't seem to be effective because it has been said that Israel is dealing with a very unique terrorist environment, and for that reason we have to carry on.
I got two for you. Try these on for size. So I was just reading today in the English version of Haaretz. There's an op-ed about the death penalty. Can you hear me, Susan? Yeah. So it's an op-ed entitled "The Death Penalty Would Be Lethal to Israeli Democracy." But there's one argument that might be convincing. So the author of this op-ed is French, and he refers to his teacher and mentor, Robert Badinter, who was the Minister of Justice in France in the early 1980s when France abolished the death penalty in 1981. And it was really his, it was at Badinter's initiative, and he was the leader of the abolitionist cause, and he wrote a book about it called La Peine de Mort, and here he's quoting Badinter about capital punishment for terrorism, because that was an argument that was made in France about why France needed the death penalty to deal with terrorism. And this is what Badinter said about that. Capital punishment may deter criminals, but between terrorists and death, there is a concealed link, a distorted and worrisome permanent connection. Capital punishment will only further increase the aura of martyrdom. So if the idea is that we need it specifically for terrorism, there might be an argument, like on that very turf, that it may just be actually counterproductive to add to the martyrdom of terrorists. Another argument, and this is something we've dealt with in the United States, so many people who support the death penalty, and this was true when Nixon brought the death penalty back just for hijacking, which was our terrorism in 1972. But did it stay just for hijacking in 1972? No, it did not. And in every jurisdiction that tried to pass a very narrow death penalty, it always ended up growing and growing and growing, what people call aggravator creep, like mission creep in military parlance, that you start small, but then it keeps growing. There's a guy, he's very famous in the US, named Scott Turow. He's a former federal prosecutor. He also is like a famous novelist, which is an unusual combination between being a federal prosecutor and a novelist. He had no problem with the death penalty when he was a prosecutor. And then he became a private defense lawyer, as many prosecutors in the US do, because that's how you make money. But he did some pro bono work in Illinois, which had a bunch of innocent people exonerated from their death row. And he was shocked at sort of the opposition, even to letting off people once they were proven innocent. And he was appointed to a commission on the death penalty in Illinois that, to his surprise, eventually recommended complete abolition, and he supported this, even though he was not in principle objecting to the death penalty. And his main reason for why he objected to the death penalty said, I have no moral objection to a narrow death penalty for the worst of the worst kinds of crimes. He said the problem is it never stays that way. I'm just going to read you some language. I brought this with me. I'm glad you gave me an opportunity to read this because he writes, he's a great writer. So he says, the furious heat of grief and rage that the worst cases inspire will inevitably short-circuit our judgment and always be a snare for the innocent. And the fundamental equality of each survivor's loss and the manner in which the wayward imaginations of criminals continue to surprise us will inevitably cause the categories for death eligibility to expand, a slippery slope of what about hims? And so the idea is like, you could tell people that, oh, it's just be Palestinian terrorists against Jews. Like, I'm all for that. But it's like, it's not going to stay that way. And then you'll never be able, to use another Middle Eastern analogy, to get the genie back inside the bottle.
Thank you. We have a few questions and only less than 10 minutes. So let's take the questions and then Professor Steiker will be able to respond.
Thank you so much. It was very interesting. I also work in the public defense office as an intern. I studied here. So I wanted to ask about this phenomenon of hundreds of people are actually in this limbo situation of like the dead man walking, waiting for their death penalty. It seems like it's actually a bigger phenomenon than people are actually going to the death penalty. So I wanted to ask if there's writing about it, and it seems like some kind of torture in a way to wait for this moment your whole life, maybe. And the second question is a bit maybe provocative about the situation in Israel, that in a way death penalty is already occurring on the ground in the case of terrorism. And so maybe there is a case, which I don't agree with it, but that at least someone will have a trial and a day in court and will not be just shot, you know, at the moment, which is what happens here actually many times, even in in cases where people are just approaching with scissors even to an army person. So, yeah.
Let's take the other two questions and then תוכל להעביר את המיקרופון לצד השני? עמית, בני.
Hi, my name is Benny. I met you last week, and I'm a PhD doctorate student here. I used to work at the public defense. I'll be a bit provocative because Carol, you got acquainted to my project about the adversarial system, and one of the main scholars on the adversarial system, John Langben, the historian, he wrote that one of the main reasons for the development of the adversarial trial, of all the evidential rules and procedures which guaranteed rights for the accused, was the capital punishment. Judges saw that too much death led for too much death for minor offenses, so they tried to deviate from the offense through all kinds of evidential rules, so the capital punishment won't be inflicted. And so we're not in that situation, but the provocative question is whether could there be something good out of it?
Well, maybe it's in the same direction. So my name is Amit. I'm a colleague of Yoav and Tali. My question is about your comment about the LWOP, the fact that if death penalty goes, then we could start fixing other things. And I wonder whether counter examples for if death penalty goes, then people with better ideas about the criminal justice systems would now might have the energy and resources to implement. So I wonder whether from the American kind of history or experience, you can think about cases in which some others' ideas were kind of put back because of the need to defend the death penalty.
Wait, I'm not sure I got that question. Could you just repeat that again?
So I'm thinking whether there are counterexamples to the examples you mentioned about the LWOP. Whether, I mean, you mentioned that if death penalty goes, then people who were against it would now fight to have further corrections of the system or to remove other bad things that are going on at the moment. And my question is if we can think about also the other direction of that. So if death penalty goes, then people now who are kind of advocates of that penalty might have more time and energy to implement or to promote other bad ideas that they have about the systems that they currently don't have the resources or priorities to mention them.
Well, just to answer that question, I mean, right now there isn't like an advocate of the death penalty like movement because we have the death penalty. So the movement, you know, to the extent that there is a movement, so maybe it would create such a movement, right? And it's sort of, I think that's what happened with Furman versus Georgia. It created a movement to bring the death penalty back. So abolition can create a backlash, especially if the abolition comes from a court, say, as opposed to organically through the political process. So I do think that's always a fear that if, you know, you move too fast or ahead of where people are, you create a backlash of a movement. But I feel like that's not where we are right now. Like the death penalty is really in a moment of dying, and we've had like 40 years of attempting, 50 years now of attempting to fix it and make it work. And so I think the fear of backlash against abolition, like we've had in the last 15 years, 12 states have abolished the death penalty, either legislatively or judicially, and it's been like dead quiet in those states. Like there has not been backlash. So I think that's less of a fear, though. You know, who knows? You know, anything could happen. Could something good come of the death penalty? Like, you know, like the way adversarialism or legalism and proceduralism may have come? Sure. When you have a very dramatic punishment like the death penalty, a lot of energy, both left and right, tends to be focused on death penalty cases, but then get more broadly applied. So I do think that the death penalty sucks the energy of people, reformers in the criminal justice system to focus on that, even though it's like a tiny part of our system, but it just sucks a disproportionate amount of energy, both good and bad. So yeah, I mean, maybe we do have protections in capital cases that we don't have in non-capital cases, a few of which have started to trickle onto the non-capital side. So Benny, maybe that's, you know, is it worth it? Yeah, no, I don't think so. Length of time on death row, the average length, so the European Court of Human Rights, like 70 years ago, said 5 years was torture to have people waiting 5 years to be executed. The average amount of time on death row in the US just surpassed 22 years. So we don't just have the death penalty, we have long-term incarceration followed by the death penalty in the US. So two of our former justices have said they think that that is a form of torture, but only two, so nowhere near enough to make a ruling in that way. And, you know, it's funny, your argument about maybe it's better not to have unofficial executions on the ground, to have a state execution. This was exactly the argument made in the southern states in the early part of the 20th century, that they needed to keep the death penalty because it was better than lynchings. So lynchings, when the white mob would come for black men who were accused of these crimes, and that was like such a black eye for these southern states. And they said, well, let's keep the death penalty. We can't get rid of it like those northern states because we need it to suppress this worse practice of lynchings. So I've heard that argument before, but not in a way that makes me super sympathetic to it. Anyway, thank you all for your questions. It's been wonderful to engage with you.